And we are live. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near, give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Morning, everyone. My name is Justice Henry, and I'll be your panel chief today. I'm joined by my terrific colleagues, Justice Lemire and Justice Shin. This is the September 17th, 2020 sitting of the Appeals Court. Before we get started, I do want to just acknowledge that we've suffered the loss of Supreme Judicial Court Chief Justice Ralph Gantz. He was a terrific jurist and a wonderful, kind person. We can all just aspire to be like him. He was committed to justice, but also to understanding how our decisions impact regular, everyday people, and tried to be practical, equitable, and he was someone who fought for racial justice. So I just want to take a moment of silence in his honor. Thank you, everyone. We have the first case on today, which is 2019-P-1707, Commonwealth versus Sergei Sargsyan. We will have our usual rules as if we were present in the courtroom. So each side has 15 minutes. There is no rebuttal. Everyone will be on Zoom the entire time, so please act as if you are in the courtroom. If we have any technical difficulties, just stay relaxed. We'll work them out and we'll make sure everybody's time is fair. And with that, we can proceed. Counsel?
Please the court. Adriana Condertesi for the defendant appellant Sergei Sargsyan. In this case, the defendant contends that the police officer exceeded the scope of the permissible community caretaking function. And the time and place that exceeding the scope occurred is really when Officer Bergdorf, and he testifies to this at page 18 of the suppression transcript, the time that scope is exceeded is exactly when Officer Bergdorf asks the defendant to roll down his window and asks for a license and a registration. That is the first question that he asks the defendant. And if that does not have all the hallmarks of an investigatory stop, I don't know what would. And I think I know that a subjective intent by the police officer is not necessarily decisive, but you can't help but wondering if this is really a community caretaking stop. When the police officer asked the defendant to roll the window down, why wouldn't he have said, "Are you okay? Everything okay?" But the very first thing he did, and he admits it quite candidly, that he asked for a license and a registration.
So, counsel, you say in your brief the defendant did not voluntarily open the window upon the Bergdorf's request. And I'm trying to understand what the basis for that statement is.
Well, I don't think that it was an involuntary action. I think it was more that he was groggy. He had just woken up. And so he wasn't really following the directions at that point. It wasn't a willful failure to open the window. But I think it is also too relevant, and my brief really focuses on that much more, that the defendant waved Officer Berghoff off. I'm okay, I'm okay.
Is there any indication in the record that the car was parked illegally or that any infraction had been committed?
No, and at trial, the prosecutor really tried to really tried to make that point, but could not get it out of Officer Berghoff. What we know is that it was a quiet, dead-end street. There were no signs relative to parking, and Officer Berghoff could not say with any certainty whether or not parking was permissible there. So there was nothing in the record to indicate that the defendant was parked illegally. There was nothing in that record at all to indicate anything wrong that could give rise to reasonable suspicion of a crime afoot. To warrant it really being treated much more as an investigatory stop than a community caretaking stop. I'm sorry, community caretaking check.
So, counsel, in Evans, the court found that the officer, by asking for the defendant's license and registration, that he did not affect a seizure because he was acting within the scope of his community caretaking function. So how do you distinguish that case?
Well, and those cases are interesting. And the interesting thing that I've noticed is in the disabled vehicle line of cases, the issue of asking for a license and a registration is an issue. But in the community caretaking cases like Murdaugh, asking for the driver's license and the registration wasn't even an issue at all. But so the answer to that is that Evans and Mateo German both featured disabled vehicles.
Well, in Evans, at least, the car was parked in a breakdown lane. It was difficult to rouse the defendant. It seems to be very similar facts. I don't read the court's rationale to be limited to disabled vehicles. It relies on a case out of Wisconsin that says that officers need to know who they're assisting. And the officer in this case testified that he asked for the license and registration so that he knew who he was talking to.
Who he was talking to, and also whether or not it was his car. Those were the two things.
Right. So it seems to me Evans is pretty squarely on point.
Well, is that in this case where we do not have an illegally parked car, we have no problem with the car, is that the first step that a police officer should take when conducting a community caretaking function, to ask the person to produce a license and a registration, just the same way that would have happened if he had reasonable suspicion of the defendant speeding or being illegally parked or something like that. If I know that I don't have a lot to hang my hat on, but you know, there is no way that when he asked that defendant to open the window in this instant case, that asking for the license and a registration was not for an investigatory purpose and not for a community caretaking purpose. And while I do understand that identifying the person and identifying ownership may be a component down the line of the community caretaking function, under these circumstances, it certainly did all the things that a police officer should not be doing in a community caretaking scope.
So under your argument, if the officer had asked him anything other than how are you, that he's doing an investigation. If he had said, "What's your name?" I mean, isn't asking for a license the same as asking him for his name in a way?
Well,
And if he had said, "What are you doing here?" then your argument is he's still investigating, whereas he's just trying to determine what is happening at that moment with this car. I mean, a neighbor had called this in. It wasn't the officer that just happened upon him.
right. Yes.
So there was concern from some other people about this vehicle's presence, and the officer was just there to determine what was happening, and the person whether the person was okay. So to ask for an identification or any questions that it would seem to me initially, other than ordering them out of the car, any questioning would be just an attempt to determine what the situation was that the officer was encountering.
Well, as I said, I don't have a lot to hang my hat on, but it really does seem to me that this investigation from the get-go, well, after the time that the defendant waved the police officer away, indicated he was fine, and the officer even said that he was satisfied that the defendant was fine. If this really had been a continuation of the community caretaking function, wouldn't the next question have been, you okay to drive? Because if you are, you got to get going. And then maybe he could have observed that there were some issues that would have warranted a further investigation. I mean, if the court wants a community caretaking check to really mimic an auto stop, then that's fine, but that is not fulfilling the goal of the community caretaking function.
So, counsel, do you have a case or some argument that just asking for a driver's license is a seizure?
Well, no, I don't. But I think that the important thing is that these issues were raised. They're of importance in Evans and Mateo German, and these are issues of importance. And to the ordinary citizen, being stopped by a police officer and being asked, "Are you okay?" as opposed to being stopped by a police officer and saying, "Can I have your license and a registration?" Those are two much different things, and that is essentially the distinction between the community caretaking function and a stop based on reasonable suspicion.
So the Commonwealth argues that no command of the defendant was made until Officer Bergdorf told the defendant to exit the vehicle. What do you say to that?
Well, I mean, by that time, the game is over. But this isn't like Murdo, where the guy was groggy and needed fresh air. By that time, the case was already over. By that time, the defendant, the police officer did have reasonable suspicion to ask the defendant out of the car. I mean, if a kitchen knife is going to do it. In my mind, the stop really exceeded the scope at the time that he asked for a license and a registration, right off the get-go, having no other indication that anything was wrong with the defendant and not making any inquiry into the defendant's condition and having not observed anything unusual. So I think that, of course, the Commonwealth is going to pick that spot because that is a place where we're beyond whether or not the scope was exceeded. I don't have anything else, so I'm happy to rest on my arguments.
Thank you, counsel.
Thank you.
Attorney Ferreter.
Good morning, if it may please the court. Timothy Ferreter, Assistant District Attorney from Middlesex on behalf of the Commonwealth. Officer Bergdorf appropriately carried out his community caretaking function in this case. The issue the defendant raises with the defendant waving off Officer Bergdorf, at that point, the purpose of that community caretaking function hadn't been completed. He, as he testified to on page 18, he wasn't sure at that point when he was waved off whether or not the defendant was able to drive or even whether or not the defendant was okay at that point. So that's why he had to take the next step and ask him to roll down the window. This isn't a case like Casado where the defendant was on foot, he was in a car. And under Murdaugh, it's important in this type of situation, in a very similar set of facts, to make sure not only that the defendant's okay, but that if he continued to drive, he would impose an extreme danger to himself and others. All of Officer Bergdorf's actions in this case are in line with the SJC's holdings in Evans and Murdaugh, asking for the license, asking some preliminary questions, all serve to carry out that community caretaking function.
So, counsel, let's just zero in on this. The officer could have said, you know, what's your name or how you doing? But instead, he asked the defendant to produce a driver's license. Is it correct that the defendant would have been guilty of a crime had he failed to produce his driver's license at that point?
Well, just factually, I believe the testimony wasn't clear exactly when all the questions were asked in what sequence. He did ask a number of questions. How are you doing? Who are you? Where are you going? Where are you coming from? And the defendant wasn't able to answer all those questions. But under Evans, they permitted the officer in the community caretaking function to request a license. And under Lyles, just the initial request for a license without taking them back to check the status isn't a seizure. So I think all those actions were appropriate in this case.
Well, is it a crime if the person in control of a motor vehicle does not produce their license when asked by an officer?
I am not sure of that answer, Your Honor.
Well, can an officer walk up to a pedestrian and ask for them to provide a license for no reason? Can they just say, I'd like to know who you are, I'd like your license?
Yes, you can have a voluntary conversation on the street with someone.
And,
police officer can.
And if the person says no, can the officer do anything about that?
No.
So I'm trying to understand whether you cite many cases that involve pedestrians. Why are those cases relevant?
In terms of the stop or the community caretaking function?
In terms of asking for this identification, because it seems like it's different where there's a statute that says that a person in control of a motor vehicle must turn over their driver's license when asked by a police officer.
I don't think it's different. I think the car was already stopped, so it wasn't a motor vehicle stop. And under Murdaugh, any police officer can go, just like they can go knock on a door, can go knock on a car window, and voluntarily ask to speak to the person and request their identification. So I don't think there's a constitutional significance where it wasn't a car stop. The defendant was already stopped and the police officer pulled up behind him. So I don't think it's a different situation than the pedestrian in this case because it wasn't a motor vehicle stop. He was already on the side of the road.
Right, but the difference seems to be that there is a statute that I believe you cited in your brief, chapter 90, section 25, that says there's a penalty for a person in control of a motor vehicle to refuse to provide their driver's license. So at that point, I want to understand the Commonwealth's position. Was this person free to say, I don't want to talk to you and I'm not showing you my driver's license?
I think he was because it wasn't a motor vehicle stop. This was a community caretaking function.
But he was in control of a motor vehicle, correct?
Correct. I'm sorry, I didn't cite that in my brief, Your Honor. I probably in the defendant's brief, but it's not something I looked into in preparation for this argument. I apologize.
So in Evans, defense counsel notes that the defendant was stopped in the breakdown lane of a highway, which as far as I can tell is never a good idea unless you have absolutely no choice. It's incredibly dangerous. Is there any indication here that this defendant was parked illegally or had otherwise committed a crime?
No, Your Honor. It was just a call for by a neighbor that someone had been stopped on the street for some time on a cold January night. Similar to Murdaugh, there was no issue with where the defendant was parked. He was stopped in a rest area. And the SJC still held that the community caretaking function was appropriately carried out in that case. So whether or not the defendant was illegally parked, I don't think is significant. He got a call from a neighbor. It took 5 to 10 minutes to get there. And when he looked in the window, he saw he was asleep. And I think it was appropriate for the officer to make sure that the defendant was both okay and able to continue to drive safely, which he did.
Go ahead.
So I just wanted to clarify your reliance on Lyles, which is not a community caretaking case. So are you arguing that in any circumstance, regardless whether an officer is a caretaking, it's never a seizure for the officer to ask someone for their license and registration?
I'm sorry, your question broke up.
Lyles was not a community caretaking case. So my question is your argument that regardless whether an officer is exercising community caretaking function, it is never a seizure to ask someone for their license and registration?
So I made two arguments, Your Honor. The first was that there wasn't a stop until the defendant was asked to exit the vehicle. There's no show of force that would indicate a stop. And even if there was a stop, it was a proper carrying out of the community caretaking function.
So you are making alternative arguments. Is that
Correct.
accurate? Okay, so
Correct. And it's a lot, sorry.
I understand your argument about community caretaking. It seems like a rather broad proposition to me to say that it's never a seizure to ask someone for their license and registration. Lyles doesn't stand for that proposition as I read it. And it seems to me, if an officer comes up to someone in a motor vehicle as opposed to pedestrian and asks for the license and registration, and the person refuses and drives away, just drives away, I think a reasonable person would assume the officer would follow. Isn't that the case? So why wouldn't that be a seizure?
I understand your point, Your Honor, but this wasn't, I think that the defining line in this case is the fact that it wasn't a motor vehicle stop. This is a voluntary interaction on the side of the road.
Let's say there is no indication that the defendant was inebriated or otherwise incapacitated to drive. He's just in, let's say, breakdown lane, and the officer, he says, I'm fine. By all outward appearances, he's fine. And the officer says, give me your license and registration. Wouldn't a reasonable person be warranted in assuming that were he to just drive away, that the officer would follow him?
I understand your point, Your Honor. I think maybe that in the motor vehicle is a different situation, but where there is a reason to interact with the defendant to make sure he's okay and to make sure that he's able to drive under Evans, asking for the license was appropriate. And I think that does go to the community caretaking function. But there's also no, I understand what you're saying about asking for the license, but there really was no indication that the defendant was stopped in this case. He was already stopped on the side of the road. There wasn't a motor vehicle stop. And an officer is allowed to speak to someone in a car just like they're allowed to speak to someone on the road or knock on their door of their house. So I don't really think there's that much significance where it wasn't a motor vehicle stop. But I think the officer's actions in this case were perfectly in line with the holdings and the facts of Murdo and Evans. It's perfectly acceptable use of the community caretaking function, and the decision of the lower court should be upheld. If there are no further questions, I will rest on my brief.
Thank you very much, counsel. We understand, well argued.
And we are live.
Good morning. This is a continuation of the September 17th, 2020 sitting of the Massachusetts Appeals Court. My name is Vicki Henry, and I'm joined today on the panel by Justices Lemire and Shin. We're hearing case 2019-P-1197, Commonwealth versus Clark. We have read your materials. Each side will have 15 minutes. There is no rebuttal, and we are ready to proceed. So Attorney Bailey, please proceed.
Good morning, Your Honors. A principal claim of error in this case is that the erroneous admission of Facebook Messenger communications between the complaining witness and the third party who did not testify. In sum, it was error to admit the Facebook messages as excited utterances. That error resulted in prejudice to the defendant. Given that these were written statements, they are required to satisfy a heightened indicia of reliability. That didn't happen in this case. That's pursuant to Commonwealth versus Musgrave. Moreover, there were significant intervening events that occurred between the underlying event itself and the writing and sending of the Facebook messages. Beyond that, the content of the messages itself all too often did not relate to the subject of the underlying event itself, but other aspects and thought impressions of the complaining witness. Your Honors, the Commonwealth, in opposition to this claim of error, relies principally on Commonwealth versus Crawford. I would suggest that that's misplaced reliance. Crawford is an oral statement, and this is a written statement, and written statements can be admitted as excited utterances pursuant to the cases we've cited. However, that involved a small child. That involved a small child who was questioned by an adult and asked, what happened? There was no time for deliberation. There was no prompting. The small child, who witnessed clearly a startling event, answered, and it was admitted as an excited utterance. This is a self-initiated, self-generated written statement by the complaining witness. That's a different situation from Crawford entirely. Moreover, Your Honors, the record reflects at least 8 substantial intervening events between the agreed upon time endpoint of the underlying event, 11:52 a.m., and when this Facebook messages were sent at 12:04 a.m.
So, counsel, I'm going to pause you here. Do you agree that the standard of review is abuse of discretion here?
I agree that it's error, and that error was preserved, and there's prejudice to the defendant here, Your Honor.
But this is an evidentiary question, so do you agree that it's abuse?
Yes, Your Honor, I do. And so these intervening events, first of all, after the defendant went into the bathroom after 11:52, the evidence reflects that the complaining witness got up and wiped herself off. After that, rather than going to the left and out the door and down the stairs and outside to where a car was parked, she followed the defendant, opened the closed door to the bathroom, went into the bathroom where he was showering, sat on the toilet for up to 2 minutes and wiped herself off again. After that, she went back into the bedroom, asked the defendant's friend if he had a cigarette, asked if she could smoke in the house. When he said no, after that, she and the friend went down the stairs outside to near where her car was parked, house outside, smoked the cigarette, exchanged small talk, then also exchanged phone numbers. After that, she followed the friend back up the stairs, back behind him, waited for him to open the door where the defendant was, went into the bedroom, got on top of the bed where the friend was sitting. After that, at 12:02 a.m., the evidence shows that she received a phone call from her mother's call. That call lasted up to 72 seconds. I would suggest to you that when she was confronted with that phone call, first she denied it happened, then she said it did, she didn't remember it, then she acknowledged if those are her phone records, it may have happened. I submit to Your Honors that could be the event that could have precipitated these messages that occurred thereafter. I would also note that beyond that, when the messages started to be sent at 12:04,
Counsel, I'm going to pause you here. What do you mean when you say that the phone call with the mother could be the precipitating event?
That could well have been what prompted deliberation. That could well have been what prompted contrivance for what followed 2 minutes thereafter at 12:04 a.m. I suggest it could be completely unrelated, and that's what this is all about, Your Honor. After that, the complaining witness indicated that she was feeling safer. She said that before much of what she wrote in this message. That too needs to be considered by the honorable court as to whether or not this meets the requirements of reliability and spontaneity. Moreover, the Facebook.
Counsel, it seems like it influenced the judge when making this decision that she was still in the situation and still potentially in jeopardy being with two. I don't know that we know the age actually of the defendant or his roommate, but that she's with these two people she didn't particularly know and still in the situation. What do you say to that?
I say that this honorable court needs to look at the totality of the circumstances. I don't deny that she sent these while she was inside the premises, but all of the other factors already cited have to be taken into account, as does the fact that the book exchange spanned a period of 23 minutes and was first initiated some 12 minutes after the event itself occurred, which means the exchange, the last exchange was some 35 minutes after the event. And we have to compare this respectfully, Your Honors, to Commonwealth versus Mulgrave, which sets the standard of heightened reliability. There in Mulgrave, It was a single sentence text message. The court found that there was no punctuation in it. The court found that it went directly to the threats that she alleged were being made. And the court found that it likely occurred while the incident itself was live. That was ongoing. That has to be contrasted, Your Honors, to the fact that this was all sent after the fact, between 12 to 25 minutes, that it was multiple statements sent after she said she was feeling safer. There is punctuation.
Counsel, could they have been admitted as first complaint?
The court ruled that the Commonwealth could admit them as first complaint. However, the court doesn't admit.
Could we determine that because they were potentially admissible as first complaint, there's no error, no prejudice, because they were an admissible evidence?
I would respectfully suggest that the Commonwealth had the election, made clear that they were admitted as being admitted as excited utterances. That's conceded in the Commonwealth's brief in footnote 5 on page 23. And as I will get to, the fact is, coming as complaint, there would have been limiting instructions. They would have been offered not for the truth of the matter asserted, as in here, they came in for all purposes, including the truth of the matter asserted. Also suggest back to the statement itself, it's clearly interrupted. It's clearly back and forth. It's not like the Mulgrave one sentence writing. On top of that, if this court looks at the record appendix, it can read through those text exchanges in about 30 seconds. This went on for 23 minutes. And I suggest that all of that provides an opportunity to liberate, takes away the spontaneity, opportunity to potentially contrive and be responses to other factors. Moreover, the contents themselves focus on her feelings about the friend. I feel safer next to him. And his friend is wicked cool and nice, and he wasn't in the room. I think he would have stopped it. She opines about the defendant's state of mind, saying that I feel he didn't mean to hurt me, but at the same time, I know he did. I don't know I have too big a heart to believe true. But more than that, Your Honor, it includes this back and forth plan, create an extraction plan to contrive having the friend call her up and say, hey, an emergency, I need you. It's the type of deliberation that's talked about in Commonwealth versus Santiago as something other than the event, which raises concerns. That's the type of thing that happened in Commonwealth versus DeMonte that I also pointed out, where it was not deemed to be an excited utterance. With regard to the prejudice,
Counsel, are you saying that the entire series of texts is inadmissible?
Yes, I'm saying the entire series of texts should not have been admitted as an excited utterance.
Well, why wouldn't, I mean, it seems like most of your argument concerns the texts that were exchanged later. So why wouldn't at least the initial text qualify as excited utterances?
Because of all of the intervening acts that I suggested that occurred prior to that being sent. I listed at least 8, maybe 9.
The first text was sent at 12:04.
Yes.
It just says OMFG. That yes. All that from my reading of the transcript, all that had occurred at that point was that she had gone into the bathroom and wiped herself off.
Well, I think it was less clear than that, Your Honor. I think she was back and forth as to whether she had already gone downstairs or not, or where it occurred.
Well, but the phone call with the mother and all that, had that already occurred?
The phone call with the mother had already occurred. That occurred at 12:02. Yes, Your Honor. Your Honor, here these were admitted for the truth. Clearly, the prejudice was established. The jury zeroed in on the Facebook messages during deliberations. In fact, their note said, our page is missing. Clearly, the verdict appears to track the off and on segments of this message as opposed to the actual testimony of the complaining witness. There was no other evidence other than her own testimony, and the Commonwealth relied upon it in its closing. For those reasons, I believe that alone should result in the verdict below being set aside. If I may move onto the argument and then rely on my brief for the remainder. Your Honor, the argument was, the argument was both inappropriate and prejudicial. Objections were made live during closing and also at sidebar. I'll just focus on those that were most egregious. After talking about the world of online dating and how that emboldens people and potential pattern of behavior, the Commonwealth stated in its closing, I suggest that this is a case of what rape so often looks like. That's going outside of the evidence. That's interjecting her experiences as a sex crimes prosecutor. That's suggesting to the jury that this is just like any other case. That's inappropriate.
So,
That was deliberate.
Counsel, the Commonwealth says that the defendant's trial strategy was to insinuate that the victim's behavior was not consistent with someone who had really been raped, and that the statement you're talking about was in a response to that. What do you say to that?
I say that that argument was made simply on the basis of the facts alone, and it didn't talk about what other people do. It just talked about what she did. This is going outside the facts. This is going beyond. She did it again when she was talking about the concept that you need consent in order to have consensual sex. She said, the concept that you need consent in order to have consensual sex is often distorted. She didn't say that concept is distorted in this case. She said often. Again, she was bringing in her experience. She was putting her imprimatur. That was improperly outside. But then she does it a third time, Your Honors. She says many cases are based in large part or sometimes entirely on the word of another person. That's completely inappropriate. And she did that in a case where the complaining witness was repeatedly impeached with prior inconsistent statements.
So why wasn't this cured by the instruction given immediately after the closing that any other cases that may be out there are irrelevant?
Because I think that that was too general for purposes. I think the horse was already out of the barn. The prosecutor had already put her imprimatur on this. And if you take the Kozak factors, it clearly could have affected the verdict in a tight case that had multiple days of deliberation that needed a TUI charge. Plus, I claim objection in the Commonwealth's statement. The law makes it very clear. If you believe the complaining witness, if you believe her testimony under oath, that evidence is enough. If you believe her is enough. I cite to Alvarez. Yes, it was a footnote. Yes, it was in response to the dissent saying that we shouldn't always comment about sex crimes cases having only witnesses, only one witnesses, but it involved a situation where the prosecutor commented on evidence not in the record. Here, it's a misstatement of the law. And yes, there was a reasonable doubt instruction given, but it was given prior to the closings. It was never given in the context of a single party, a single witness case. And based on Kozak, there's no question that those errors could have made a difference in the jury's deliberation in a case like this. So I respectfully suggest for that reasons and the other reasons cited in my brief that the case below should be reversed and the guilty verdict set aside. Thank you very much, Your Honors.
Thank you, counsel. Attorney Spate?
You're on mute.
You're on mute, counsel. It's okay. These things happen.
This is my first Zoom argument. So, good morning. May it please the court, Hallie White Spate, Assistant District Attorney for Middlesex, on behalf of the Commonwealth. To take the issues in order, the Facebook Messenger communications were admissible as excited utterances, and the judge was well within his discretion to admit them as such. The victim here was a 17-year-old girl, someone for whom texting was as natural as breathing. Her entire acquaintance with the defendant had been carried out by means of text messages on various platforms. Her way of communicating with her friends was by text. This was a spontaneous mode of communication. It's not like DeMonte.
Counsel, did Jane testify to that this was her normal mode of communication?
Not as such, but the evidence was clear that her communication with the defendant certainly was entirely by, I think she testified there may have been 1 or 2 voice calls, but it was entirely by text. And I think she falls squarely within that class that is discussed in Mulgrave, where for a person proficient in the use of cellular telephone technology, sending a text message may involve no more effort than verbalizing a thought, feeling, or emotion in response to an event. And this is very distinct from the case in De Monte, where the victim writes out a statement and then sends it by fax to her friend, and in the middle of the statement talks about something that's completely outside the supposedly exciting event. Oh, we have this concert coming up and I think someone can't make it. Can you take care of that? Which works, obviously. That's De Monte. And just because the defendant wants this court to distinguish Mulgrave, but just because the statement in that case, 1 sentence, no punctuation, right in the middle of the event, just because the utterance there was more urgent, more excited, doesn't mean that this statement doesn't qualify. And again, this is an abuse of discretion standard. And so this court has to find that that the judge made an error in weighing the factors appropriate to the decision such that it falls outside the range of reasonable alternatives. That simply is not the case here. That may have been some, sorry, yes.
The defendant argues that the jury verdicts track Jane's statements in these messages. What do you say to that?
I don't disagree with that, but I don't think that makes them inadmissible. That's not the question for this court. Yes, the jury does seem to have put some weight on them, but that matters only if they were not admissible, and they were entirely admissible. The fact that another judge might have decided the matter differently does not change the analysis.
Counsel, I didn't see anywhere in the record where the judge explained his rationale for admitting the text. Do I have that right? I just want to confirm that.
I don't think there was a separate order. Was
there anything on, I didn't see anything in the transcript. I just want to confirm that I'm not missing something in the record.
No.
Okay.
No, but I think it's clear that he's adopting the reasoning in the Commonwealth's filings and its arguments at the hearing. But there was not a separate explanation. That's right. His was after hearing aloud.
Counsel, there was, before the statements were admitted, I think there was one question as to her state of mind, and she said she was scared.
Yes.
There was no other information about her present state of mind, in shock, or
I think
afraid of these. I mean, she just said one. I think it was one word. I was scared, or one.
Yes. Yes.
And then the judge immediately admitted them.
But this was after an extensive hearing on the admissibility of these statements and on the facts surrounding the admission, the making of the statements. I think scared by itself is probably sufficient, but if you look at all of the circumstances, this is a 17-year-old girl. She's far from home, late at night, alone in an apartment with 2 men she doesn't know, one of whom has just raped her. She has a license that doesn't allow her to drive after midnight. And she needs to find a way to escape. I don't see why that doesn't qualify. I think that that taken all together is more than sufficient to qualify them as excited utterances. And that being the case, they come in for their full value. And the idea that for some reason they don't meet the criteria for more limited admission as first complaint or prior consistent statements somehow makes them inadmissible. I think that gets the law backwards.
So, counsel, defendant argues, well, this all happened right immediately after the phone call with the mother, and that either prompted a motive for contrivance or gave some time for reflection. What do you say to that?
I think the defendant below and on appeal is speculating about what that call was and what was said during that call, if anything. The victim said she did not remember the call. The mother didn't testify. It is a possibly countervailing piece of evidence, but I don't think by itself it's sufficient to nullify all the evidence that she was young, alone, scared, proficient in texting, and needing to quietly find a way to get away. She goes out to smoke a cigarette, and by the way, I think I'm pretty clear the evidence was they were her cigarettes, and Eddie, the defendant's friend, asked her, "Can I have one? Can I come out and smoke with you?" And she was not expecting him to follow her. She was thinking, "I'll go out and I'll have a cigarette and I'll figure out a way to get away," I think was the inference from that. So she has reason not to want to be overheard. And I think.
I'm sorry, go ahead.
Sorry, no, I'm done.
So because these are written statements, they have to satisfy at least some heightened indicia of reliability. I understand their text. Shouldn't the Commonwealth be required to do more than simply elicit the one word scared as to her state of mind?
I think when they've already been ruled admissible, I think that's sufficient.
They had not been ruled admissible.
No, the judge admitted them.
I thought the judge admitted them after she said, she was asked the question about her state of mind. She says the one word scared, and then the judge admits them. Shouldn't we require the Commonwealth to do more?
I think the Commonwealth. I'm misunderstanding the question, but the Commonwealth at a pretrial hearing on the motion in limine went through the whole complex of circumstances and based
and that was not
single.
That was not an evidentiary hearing, and the judge didn't rule on the motion. He waited to see, what the testimony was, and
No, he did. He did rule on the motion, didn't he? I mean, I don't know what the date is on that endorsement, but he did right after hearing aloud. And I think that one word isn't the only foundation that's needed. It's the entirety of the circumstances which she had testified to, and she had testified to the primacy of texting in certainly.
Right, but it's a very difficult question to answer in these circumstances where you're concerned with written statements, and just to make a comparison, when you have a 911 call that's recorded, the judge is able to listen to it and ascertain whether the caller is excited. And here we just have text, so we can't ascertain what her state of mind was really from the text. So it seems to me that Commonwealth should have done more than simply elicit the one word scared, right? Where there is a heightened indicia of reliability.
Well, I think the Commonwealth did elicit all of the evidence leading up to that one word answer, and I don't think this court should ignore all that other.
No, I'm not saying we should. I'm not saying we should ignore it, but I understand it's an abuse of discretion standard, but I think the defendant does have a point that there was some passage of time and some intervening events, and all
of that was thoroughly exploited at trial by the defendant, and he argues extensively in his closing about, well, what went on in that call with the mother? You have that call with the mother. You have all this time passing. She goes into the bathroom. She goes out to smoke a cigarette. This was all part of the defense case. None of that was kept from the jury.
I understand, but we're talking about
including the countervailing evidence.
We're talking about whether the text should have been admitted, not the evidence at trial. So anyway.
No, I understand that, but I also think that where we have all of the circumstances established, I think this court can't simply say, well, she only said one word, because she didn't only say one word. She had her entire testimony up to that point, all of which supports this being admissible as an excited utterance.
I think, though, that Justice Shin's point might be, and she can explain for herself, of course, that you're asking us to make some inferences from the fact that this person, Jane, is 17 and alone with two people she doesn't know. Whereas we don't have her testimony as to her frame of mind other than the one word scared.
I think that misreads the transcript respectfully. We have her testimony that when she arrived, you know, and Eddie comes out in the parking lot, he seemed really excited, and that seems strange. And she walks in and she's expecting a party, and there's no party, and that made her feel uncomfortable. And then Eddie leaves the room, and that makes her uncomfortable. And she testifies throughout about her mounting concern about what's going on here, that she repeatedly told the defendant no and stop and asked him not to. I think there is a wealth of evidence from which this court can infer that those messages were a sincere and frightened attempt to figure out a way out of this situation. And the mere fact that there was a call that came in between where we don't know what was said is not sufficient by itself to render them inadmissible.
To be clear, we have no idea whether she even spoke to her mother. I mean, 72 seconds could have been getting voicemail, right?
She said she does not remember the call.
Okay. Are you arguing that these texts could be the first complaint witness even without a limiting instruction?
Not without a limiting instruction. If they're first complaint, the instruction has to be given, and they're admissible only as corroboration. But I think Stuckich does make clear, and that was the import of this marginal notation on the defendant's motion, citing Stuckich, that if her first complaint was made via text, that is the first complaint. I mean, I think that's what Stuckich says is, if she did it in a letter, the letter is the first complaint. And that's all that imports. But yeah, I think if it were first complaint or prior consistent statement, there would have to be a limiting instruction.
Would the third party witness have to testify too, or no?
That's not clear to me, and I don't know of a case that says it is or it isn't. I mean, Stuckich seems to imply that the letter by itself could come in, because what Stuckich says is the letter is the evidence. But I don't know of a case that's tested it. But since it wasn't offered as first complaint here, I don't think the court needs to concern itself with that.
Were the text messages between the defendant and Eddie admitted into evidence?
Yes.
And do we have those in the record appendix?
Yeah, I don't know if we have them in the record appendix. Their content is testified to.
Okay, so whatever. Eddie
in full detail.
Read them. Okay. All right.
Yeah, they were in there. They are clear in the record. As for the closing argument, it was clearly within the bounds of proper argument to ask a jury to set aside its preconceptions and its prejudices and stereotypes about rape, where the entire thrust of the defense was that the victim did not behave like a, quote, real, unquote, rape victim. He says in his closing, her actions are what matters. Look at her actions. There's this allegation that if she had really been raped, she wouldn't have gone back into the apartment for her keys. She would have made Eddie do it and stood there with her phone finger ready to dial 911 and record everything if he didn't do it. She was supposed to have.
But counsel, he argues that it went beyond that the prosecutor put her her stamp that she, does a lot of these cases, and this is how it often looks. So
I think that stretches what was actually said. What was actually said was, I would suggest that this is what rape so often looks like. There was no, let me tell you, I try these cases all the time and we see this all the time. It was simply, he's telling you this was not real rape because of the way she acted. You should not accept that. Yeah, and to the extent that it might have been better said differently, I think the judge's forceful instruction at the very beginning of the final instructions after argument that you're to decide this on the evidence before you and not any other case was sufficient to cure any possible hypothetical prejudice from that argument. The rest of it, I see my time is running out. I don't know if the panel has any questions about the other issues. If not, I will rely on my brief and ask this court to affirm the judgments.
Thank you very much.
And we are live.
Good morning. This is a continuation of the September 17th, 2020 sitting of the Massachusetts Appeals Court. My name is Justice Henry, and I'm the panel chief today. I'm happy to be joined by Justices Lemire and Shin. We're going to call the next two cases. They are paired with one another. They are 2019-P-1081 and 2020-P-0045. Both cases are captioned EO versus PD. They are partially impounded, so we have PD arguing with us today, but his video is off because of the impoundment. He will have his time to argue, and we can ask questions. And we have read all of the material, and so I would encourage him to jump to the heart of his arguments, and we can proceed. PD, you may start. And again, I just remind you, because the case is partially impounded, to refer just to EO or E or the other side, okay?
Yes.
You may begin.
Good morning. First, I'd like to thank this honorable court for the opportunity to be heard today. I'm PD, the appellant and respondent in this case. And today I'll take roughly 15 minutes of your time to pose two recurring questions. The first is whether the lower court consistently erred in finding that the plaintiff met her burden of proof in a series of Chapter 209A hearings. And the second is whether, if in doing so, it violated fundamental fairness and due process protections provided by the Massachusetts Constitution, the US Constitution, the legislation enacted by the Commonwealth of Massachusetts, opinions and rules promulgated at the appellate level, and ABA recommended guidelines on fairness. At the conclusion of my oral argument, I would respectfully request that this court return findings in the affirmative to both questions. In Yamile v. Asselin, the court held that the plaintiff must sufficiently prove her allegations for Chapter 209A order beyond a preponderance of the evidence. And for abuse prevention hearings, this essentially means that the lower court needs to conduct a two-prong test, where in the first prong, it determines that an assault and battery had indeed occurred, or in the alternative, that the plaintiff had a reasonable fear of serious bodily injury or death. In the second prong, it need only determine that the parties were in a familial relationship at the time. And as the record evidence clearly demonstrates, neither of these two prongs were sufficiently met for a Chapter 209A order to issue. Let's see. So as fully explained in my written brief, this case does not apply to actual harm, but to whether the plaintiff had a serious fear of, a reasonable fear, of serious bodily harm. Specifically, when interviewed by the police back in 2016, she stated that she was not injured, but felt very much so afraid that she was going to be hurt. And that comes from the page 3 of the police report. So this case does not involve photos of injuries or medical records or things of that nature that would put it in line with an actual assault. So in examining whether a Chapter 209A order should issue based on reasonable fear, the statute also requires that the perceived threat be imminent. And in this regard, the plaintiff's claims are clearly untenable. Not only did she continue to share classes the morning in question, but she also continued taking classes for about a week before contacting the university and not the local authorities. In the latest hearing, she testified that although she had graduated from the program, she returned to the campus, to a single building where we all studied and taught, in order to meet with faculty and staff, thereby placing herself in a position where she either knew or reasonably should have known that our paths might intersect. These actions don't buttress a claim of abuse or even fear of abuse. And so I'd like to pivot to the second prong of the analysis. According to sections 1 through 4 of Massachusetts General Laws, Chapter 209A, family or household members are defined as either being married, cohabitating, co-parenting, or engaged. These 4 sections, taken in concert, suggest parties who plan for a future together. And it is the lower court's liberal interpretation of this last section that form part of the basis of my appeal today. In examining whether an engagement relationship exists, the statute also mandates that the court probe into 4 additional considerations. First being the length of time of the relationship, then the type of relationship, then the frequency of the interaction between the parties, and finally, if the relationship was terminated by either party, the length of time that elapsed since the termination of the relationship. And as with the first prong, not a scintilla of proof had been offered to support allegations that a family relationship existed, let alone the sufficiency amount required by the law. So despite the absence of a birth or marriage certificate, despite the absence of a lease or mortgage agreement signed by the parties, despite the absence of an engagement ring or projected date for marriage, or testimony from a mutual friend or a classmate acknowledging the 2 of us as a couple, or testimony from a sibling or other family member stating that we've attended family functions together. So despite the absence of all these evidentiary possibilities, the lower court consistently found that the plaintiff and I were family members from the same household. Now, it didn't make those findings explicit, but nevertheless, they're implied by the issuance of the orders. And I submit that such findings were not only unfounded, but they also defied common sense and were plainly wrong. Now, it's important to note that in the last hearing, the plaintiff also vehemently disagreed with this family and household member status, arguing that we were very much a family. And I suppose that with the passage of time, it's not uncommon that people's positions can harden. But if we go back to 2016, when the report was completed, we see that she clearly pushed back against this position of a family or household member. Again, directing the court's attention to the police report on page 2, where she stated that that what she stated in the report was correct, and what she stated to them, meaning the police officers. The only concern she has with the report is with the word boyfriend that's enclosed in quotation marks. She never referred to the plaintiff as a boyfriend, although they had been in an on and off relationship since meeting in March 2016. So I highlight this paragraph to illustrate why important and long-lasting findings cannot rely solely on one-sided testimony. That testimony is wavering and it is unreliable. And if we take this reasoning to its logical conclusion, then conflicting testimony, absent any corroboration, does not meet the Yamile standard. It simply can't. And the only way for the lower court to consistently find that the plaintiff met Yamile is that it had to consistently lower the standard. It committed the fallacy of replacing the quantity of the evidence presented with the quality of a specific piece of that evidence. In other words, it based the issuance of the orders entirely on whose testimony it believed to be more credible at the time, without any regard for where the totality of the evidence rested. Now, this type of subjective analysis may be acceptable had the plaintiff called into a local radio station to complain or participated in the cancel culture on social media, but it has no place in a court of law. In a court of law, the standard is that the plaintiff's version of events is more likely to have occurred than not. That's the preponderance. That's Yamile. And this standard was never intended to be used as some form of comparative analysis. Now, I'd like this court to also take judicial notice that an impartial jury back in November did not buy the plaintiff's version of events. So we're not here to rehash or relitigate those claims. Again, the reason we're here today is to review whether it was proper for the 3 Chapter 209A orders to issue based on the evidence before this court. And how you answer this question has the effect of swinging the pendulum back to the center with respect to abuse prevention hearings in Massachusetts. Now, after becoming an unwitting participant in these proceedings, I read a number of opinions that have been uploaded to the court's website. And the types of cases that are being brought before the court seem to gravitate toward a very dangerous extreme. Rather than hearing genuine cases of family abuse and family violence, of which I am in complete support, the lower courts are entertaining cases that involve plaintiffs, and in this case, not even a family or household member, who merely express apprehension and ask that an order issue for their own nefarious reasons. Excuse me, my mouth is getting a little bit dry.
That's fine.
I'm sorry,
There's no need to apologize. Just take a moment and get yourself situated and resume when you're ready.
Okay, I think I'm ready now. Thank you though, Justice Henry. So what I find particularly troubling about this trend is that the lower courts either can't distinguish between these two types of cases, or even worse, it doesn't care to make the distinction. And I know that might sound harsh, but the actions that have accompanied these erroneous findings seem to bear this out. Now, some of those actions don't involve violations or protections to violations, and therefore not reviewable on appeal. But other actions do violate protections, specifically the right to a fair and impartial hearing, the right not to have the court rely on matters outside of the case before it, and the right to bear arms and not have a court order issued to a non-resident to surrender his. Now, this court has published opinions on the latter two ad nauseum, and I'd like to defer to my written briefs for those.
So PD, I had a question about this because we don't decide things that we don't have to decide. And my understanding is that the record indicates that you don't actually have any firearms. Is that, am I misunderstanding, or am I?
No, that is correct. I think the concern was that the orders consistently made this request, which kind of goes to whether the judges at the lower court are actually honoring the Donovan case. So that's kind of like why I brought it in there. Not so much that I have a firearm, but the fact that consistently they have been making that order on me.
Okay, we can hear some background noise. You can still proceed. I just want to make sure you knew that.
Okay, sorry about that. So if it pleases the court, I will spend my remaining few minutes addressing the need for fair and impartial hearings. First, I'd like for you to consider this case. It dates back to October 28th, 2016. I was the subject of a hearing that seriously infringed on my personal liberties, a hearing that intentionally excluded me and was conducted outside of my knowledge. And to this day, it's inconceivable how an impartial fact finder can make a competent determination on credibility without the participation of all interested parties in the case. Add to that, a local police officer, handpicked by the university, also conducted a one-sided investigation that she offered to the court as an objective instrument. And the same judge who held the ex parte hearing with the plaintiff is the same judge to preside over the hearing to make the order permanent, as well as the linked arraignment proceedings, obviously ruling against me in those as well. Now, despite finding that the plaintiff and I were family members from the same household, Chapter 209A orders were knowingly mailed out to different mailing addresses. Fast forward 3 years later, the same judge who denied a number of my pretrial motions and presided over the linked jury trial is the same judge who issued this latest Chapter 209A order. And those pretrial motions, by the way.
So PD, the hearing that you say excluded you, was that the hearing where the 10-day order issued?
Yes.
All right, proceed.
Okay. So those pretrial motions, by the way, were not frivolous. They cited primary authority that was binding on the lower court, your binding authority. One does not need to pay particularly close attention to these statements to find a gross due process violations in my experiences with the lower court. And a part of me gets it. I understand that there are practical and logistical concerns with bringing in a fresh pair of eyes to consider linked cases. I do. However, these concerns should not and cannot outweigh the protections afforded by our rule of law. And again, that rule of law being state and federal constitutions, state statutes enacted by the Commonwealth, opinions and rules promulgated at the appellate level, and just the basic fundamental fairness that is the linchpin of the legal community. Moreover, the danger of combining in a single judge the power to decide initial as well as linked cases is obvious. Judges are people. They're individuals with biases and preconceptions that I can only hope they leave at the doorstep of the courthouse before going in, donning their robes, and deciding cases. Where I am less hopeful, however, is in instances when a judge believes the plaintiff to be more credible in one hearing, the initial hearing, and then the same judge is expected to be objective enough to believe the respondent more credible in the linked hearing, based on essentially the same testimony from the same parties. Judges are people. They're not laptop computers that can have their hard drives erased after each and every hearing. And as such, it is unrealistic to expect that they somehow retain their objectivity or impartiality after taking that first bite of the proverbial apple. And it is for this reason that I ask that this court reverse the decisions of the lower court and grant the relief requested in my written briefs. Again, thank you.
Thank you. I think we understand your arguments. You've done a very good job. I just want to make sure, is there anything else that you want to tell us? It seems like you were very thorough, but I just want to give you a moment to think about that.
No, ma'am. I think between my oral argument and my written argument, I think it's
We are live.
Good morning. This is a continuation of the September 17, 2020 sitting of the Massachusetts Appeals Court. This is our last case this morning. Case number 2019-P-1427, Yee versus U House Boston Inc. and another. Each side can be assured that we have read your materials and we are familiar with the record. I would encourage you to jump to the heart of your arguments, but it's your time to use as you wish. You each have 15 minutes and we do not have rebuttal in the appeals court. So with that, I would invite Mr. Ciccarello to proceed.
Thank you, and may it please the court. As you know, I represent Mr. Yee, and I would suggest to you that the question, as far as my client is concerned, is can a moot court take it upon itself to dismiss a case when A, no party had required it to do so, and B, that it was contrary to the rules of the court. We suggest that it's a legal axiom that the litigation should be decided by merit, not by technicalities. The motion judge in this case did not do that. In summary, the case dealt with a judge who wanted to dismiss with prejudice when it was contrary to Rule 4J, which governs dismissal for failure to serve, and that it dismissed it contrary to Rule 12b-6, and that the motion to dismiss was not filed in accordance with Superior Court Rule 9a. We feel that my argument is that the court acted sua sponte when it dismissed the complaint with prejudice when nobody had requested that, defendant didn't request it. It was contrary to the rules of court, and it was abuse of discretion. And so therefore,
I want to just have a factual question out of the way. The defendant is saying that the February motion and the May motion were identical. Is that you agree with that or you disagree with that?
I agree with that, but I don't think that I think it's irrelevant. I think that the issue with the Rule 9A, if I may expound upon that, is that I think it's very clear that Rule 9A gives two propositions. One is that that the moving party has to submit it to the non-moving party, and it can't be sent electronically in pre-COVID issues. It has to be sent to either mail or hand, unless there's a written agreement, and I don't believe that there was. And that the within 10 days of service after that, referring to the February motion, that there's just two propositions that a moving party has to do. The first is that under the rule that I have to file a Rule 9A package with the court, or two, notify all parties that the motion has been withdrawn and will not be filed.
But counsel, it's within 10 days of service of the opposition. And
That's correct, Your Honor.
And there was never an opposition served. So how is there a violation of 9A?
Well, because they have to file it with the court within 10 days, or they have to withdraw the motion. There's not a third proposition. They can't hold it. I would suggest that even with the fact that there was no opposition.
Counsel, they filed it as an unopposed motion.
But that was the May, pardon me. I'm sorry.
They filed it as an unopposed motion.
That was in May. There was two motions to dismiss. There was the February one, and there was the May, well, it was actually April 28th. But the issue is that the April 28th motion had to be hand delivered, or it had to be mailed.
No, it was. Does someone have their video on? I'm getting feedback. It was the same motion that was served in February of 2019. And Rule 9A that requires either filing within 10 days or notification that the motion has been withdrawn. Both of those actions are measured from the date of service of the opposition. Since there was no opposition that was served, that time never started running. And I don't see why at some point, you know, when the plaintiff or the defendant has waited for that opposition, that they're then required to reserve the identical motion that you already had.
I would suggest, Your Honor, because it's the point of the rule is that the non-moving party knows what the motion is filed, and there's a reason. There's a procedure in which is the moving party has to adhere to, and so that the non-moving party knows what it has to deal with.
And there's a procedure for the non-moving party, which is that within 10 days of service of the motion, the non-moving party has to serve an opposition.
And I would suggest, Your Honor, that they have 10 days after the opposition would have been served, then to either file it or withdraw it. There's not another possibility.
That's not what the rule says. And well, frankly, that doesn't really make any sense to the economy.
If I may, Your Honor, I hope that noise didn't disturb you. I don't think that's the issue. The issue is that it was served. Well,
let me ask you this. You're raising a 9A issue, but the only thing that's technically appealed from here is the denial of the motion to vacate by Judge Henry.
Yes, Your Honor.
Under Rule 60.
Yes, Your Honor.
And that should have been limited to excusable neglect or fraud or some inadvertence or some of the reasons outlined in the rule.
Yes, but in that
you never moved to strike or reconsider the dismissal. You only moved to say, so we're considering whether or not Judge Henry, in his denial of your motion to vacate the dismissal, abused his discretion.
It's correct. And I'm saying in my argument in my brief is that he abused his discretion on 2 points. The first is that he dismissed it with prejudice, which is not allowed.
He didn't dismiss it. It was already dismissed. He was just considering whether to vacate a dismissal.
Right, but the earlier motion, the earlier order that asking to vacate was a dismissal with prejudice, which he's not. I would argue that 4B only allows him to dismiss it without prejudice, Your Honor.
But you didn't appeal that.
I'm saying that I'm asking to vacate that motion, which was dismissal with prejudice, which he's not allowed to do. So therefore, it was the judgment was void, I believe, that because it was dismissed contrary to the rules of the court. The second thing is, as Your Honor is that it was that the U House Boston complaint, a part of the complaint, was dismissed because failure to state a claim. And I was able to, and I believe that I put in that there was sufficient facts to show that there was enough that there was enough evidence there that there was being able to state a claim. For example, that there was a employment relationship between U House Boston. The defendant had argued that U House Boston hadn't been incorporated at that time, yet there was a New York complaint that they had filed earlier with the court showing that there was a claim against Mr. Yee for failure for misappropriation of funds. And so therefore there was at least some type of employment relationship. And so that the court should not have dismissed it under Rule 12b-6, which is a very small, a very low threshold. And so I would suggest to you, Your Honor, that in both those cases, the judge had not followed the rules of court. And so therefore the judgments were void and my client was not provided due process. So I would suggest to you, Your Honor.
What section of Rule 60 are we under?
Which section, Your Honor?
Yes.
I believe that it was 60B, 60B2, I think.
Okay.
But Your Honor, the issue is that the filing the complaint, filing the Rule 60B motion was showing that the court should vacate that dismissal, and at least if they wanted to file it dismiss it, but dismiss it with prejudice. The fact that they dismissed it dismiss it without prejudice. The fact that they dismissed it with prejudice is contrary to the rules, and I would suggest to you that that was an appealable issue that you can decide should not stand. So I would suggest, Your Honor, that in both those cases, the rule should my 60B motion should be overturned. The vacating of the dismissal should be allowed. If you have no other questions, I stand on my brief.
So the defendant argue that you've waived the 4J argument about dismissal with prejudice by not raising it before the trial court. What can you point to somewhere in the record where you raised that issue before the trial court?
Well, Your Honor, I believe that by waiving it, by saying that it was dismissed with prejudice, I believe that that's a 4B issue. It logically comes from that argument that they because how does the judge have the right to dismiss the complaint with prejudice? You have to look at 4B. And if I argue that it shouldn't have been dismissed with prejudice, it's a logical direction from that it would be that I was not waiving Rule 4B.
Does anyone else have a?
If there's no other questions, I stand on my brief. Thank you for your attention.
Thank you, counsel. Attorney Maloney.
Yes, good morning, Your Honors. And may it please the court, I'm here before you this morning on behalf of the appellees, U House Boston Inc. and U House USA Inc. Can you hear me okay?
Yes.
Thank you. I'm before you today asking you to affirm the lower court's decision denying the plaintiff Yee's 60B motion. I believe the court has already hit the main question on the head, and the crux of my argument today is the fact that Attorney Ciccarello's arguments before the court today are mostly untimely, and that the review today should be limited to just the 60B motion and not the prior judgment before the court. Mr. Yee's argument is untimely and not properly before this court today. His various arguments regarding the alleged rule violations and like arguments cannot be put forth before this court this morning, as a party cannot use a motion under 60B as a substitute for a timely appeal. The fact of the matter stands that there was no motion to reconsider that earlier judgment, Your Honors. There was no motion to appeal that timely, and before the court today is only the 60B motion and the denial thereof.
Well,
Mr.
counsel,
Yee.
I do understand your point, but I want to be clear. Did the defendants, it seems like based on the motion papers, the defendants were asking for dismissal and they did not ask specifically for dismissal with prejudice. In fact, there's a reference to dismissal without prejudice in their briefing. Is that correct?
Your Honor, there is, if I stating the record correctly, there is no specific request for prejudice or without prejudice within the motion papers. So the court took it upon itself to say that it was with prejudice, number one. Number two, to add to the 4J waiver argument you asked about previously, the actual judgment itself says that it was entered under 12B6 and not under 4J. So I believe that that argument, doesn't hold any water, that the dismissal was under 4J.
And is it your position that the issue of prejudice or lack of prejudice would have to have been brought under the dismissal, an appeal of the dismissal, and not an appeal of the motion to vacate?
Yes, Your Honor, unless there was some sort of extraordinary relief he was asking for underneath that 60B motion, to go back in and argue the merits of the motion to dismiss at this juncture is far too little too late. I think that it should be limited. That argument should be limited to any request for reconsideration or a appeal of that original judgment. Yes.
If I may just clarify one point. In your brief, you say that in order for the appeal period from the original motion, or the original order, the judgment, to be told, the motion had to be filed within 10 days. And it's actually the service date, not the filing date. So I want to make sure that I have the timeline right, which is that the judgment entered on May 16th, 2019. The 60B motion, or what you say is a 60B motion, was served when? I have June 11th, 2019. I'm basing that on counsel's affidavit that he filed with the Rule 9A packet. Do I have that right?
I can certainly check on that.
If it is in fact June 11th, that would still be well past the 10 days, but I wasn't sure if that date was actually right.
Sure, his motion paper is dated June 10th, and that's record 2-4.
So it was served on or around June 10th or June 11th.
Served upon me and then filed upon the court on June 28th, Your Honor.
Thank you.
So in your brief at page 14, you argue that Yee's counsel somewhat suspiciously failed to properly report the filing of his Rule 60B motion on the civil docketing statement before this court. Could you explain what you mean?
Sure. I was simply referring to the fact that I believe that his appeal of the 60B motion should be limited to just that, and using it as an end run and not checking off that box to alert that the appellate court, to alert the appellate court that the 60B motion should be the only decision before this court and not the judgment. Your Honor, I believe that he's trying to do a clever little end run, whether that be a clerical error or not, I'm not sure, but I wanted to point that out to the court, that the only issue before the court should be the denial of the 60B motion and not the actual entry of the judgment, which was not appealed back in May. Your Honors, I think you see the where we're going here with the argument. I do believe that it's untimely. I think that the 60B motion is reserved, like I said, for extraordinary relief, and there has been no specific showing by the appellants that there was any abuse of judicial discretion by Judge Henry, who entered that denial. And even though the phrase is used numerous times before the court, it doesn't explain under what theory that judicial discretion was abused. I think that the review, again, should be limited to the to just that motion and not an end run around the judgment and lack of reconsideration or appeal thereof of the May 2019 decision, and that regardless, all the errors and delays can be attributed to Yee and or his counsel's inaction in actually responding to that motion to dismiss, ignoring the filing of the judgment that was entered thereon, and the deadlines for the reconsideration and appeal of that judgment. I don't believe that there is any error committed on the court below, and respectfully ask that this court affirm that decision. If there are no further questions from your honors, I rest on the papers.
Are there any further questions?
I have nothing.
So the record is clear. The Judge Henry to whom you were both referring is not this Judge Henry. It is a judge of the trial court, and no relation to me.
Judge Bruce Henry.
Correct.
So hearing no further questions, we understand everyone's positions. You've been very clear with us. We thank you.